Hi everyone, this is Casey Swegman from the Tahirih Justice Center. I'm going to go ahead and get us started. It's 2 o'clock Eastern Standard Time here, and it looks like we've actually got a good number of people on. So we're going to go ahead and get started with the webinar. So as I said, I'm Casey Swegman. I'm the project manager for the Forced Marriage Initiative at the Tahirih Justice Center. And I'm here with my colleague Dina Baki, FMI Project Associate, and we'll be hosting the webinar today as part of the National Network to Prevent Forced Marriage quarterly webinar series. We're so pleased to have with us remotely Anver, Emon, Persia Etemadi, and Deepa Mattoo, who will be sharing the curriculum entitled Youth Agency and the Culture of Law. The curriculum, which is available for free online in English, Arabic, French, Punjabi, and Urdu, aims to help students explore the legal concepts of age of majority, minimum marriage age, and guardianship in Canada. It's in this context that the curriculum introduces the concepts of forced marriage and emancipation as particular problems for students to consider. The presenters will be sharing with us a brief overview of the curriculum content, the process of consultation with teachers and the NGO community in refining and finalizing the content, as well as progress with implementation and teacher and student reception, as well as reflections on the impact of the newly passed Zero Tolerance for Barbaric Cultural Practices legislation in Canada. Anver Emon is Professor of Law and Canada Research Chair in Religion, Pluralism, and the Rule of Law at the University of Toronto Faculty of Law and serves as the Director of the Forced Marriage Curriculum Project. Persia Etemadi was the Principal Drafter of the curriculum and is currently a JD MSW candidate at the University of Toronto. Sarah Pohl is the Director of Law in Action within Schools, and Deepa Mattoo is a staff lawyer with the South Asian Legal Clinic of Ontario. Before getting started, I just want to remind everyone that we will be taking questions live during the webinar, and the way you can ask a question is by toggling over the toolbar from GoToWebinar that should be on the right-hand side of your screen and clicking on the questions box. You'll get a drop-down that will allow you to type in a question and submit it, and myself and my colleague Dina will be monitoring that box for questions that come up that we can then present to the our colleagues in Canada. So please feel free to ask questions as the webinar is going along. We want this to be as interactive as possible. And I will also remind everyone that this webinar is being recorded and will be made available on our website, preventforcedmarriage.org. And with that, I'm going to hand it off to Anver. And Anver, I'm giving you control of the mouse and the keyboard now.
Oh, thank you very much, Casey. It's a real pleasure to be here. And I want to thank Tahirih and Casey for inviting all of us to come and present to all of you today. It's a bit strange to be in a classroom that's empty and lecturing to you all, but I'm delighted to know that there are a number of folks out there right now. Just to give you a sense of, oh, this isn't working. I'm trying to scroll down on the slide, and I'm not sure why it's not working.
Try again.
No. Casey, do you have control of it?
Sure, you should, but I'm going to also go ahead and move it along.
That would be great if I could just get the next slide from there. So the idea of this particular project is one about reflecting on law broadly as a cultural artifact or as a cultural vehicle for thinking about youth agency. The project itself came out of a couple of personal experiences I had, one in a high school classroom and one at a conference actually organized by the South Asian Legal Clinic of Ontario, where when confronted with the actual data and voices of those who had been subject to forced marriage, it became very clear something had to be done. At the same time, it seemed that governments around the world felt that legislation, particularly through the criminal law, was the most efficient, if not the most effective vehicle. And as an educator myself, that just seemed rather short-sighted. And so we were very fortunate at the law faculty to have the Law in Action Within Schools program, then led by Alexis Archibald and now Sarah Pohl, who offered a vehicle, an institutional link between the law school and high school teachers, curriculum design, and whatnot. So it was in that institutional context that this particular project took hold. I'll speak primarily to issues of background of the project. I will leave it to Persia to talk about the curriculum content design and development. She'll also discuss the community consultations we did, rather that she did. I was away for the year, and she did a remarkable job managing both the drafting and the consultations, as well as thinking through revisions that had to be done in light of new legislation in Canada. Then you'll hear from Sarah Pohl, who will speak about teacher consultations and student workshops through this curriculum. And then finally, Deepa Mattoo will be speaking about the NGO and community engagement element. If I can have the next slide. So just to give a small backdrop in terms of how a project like this takes shape, part of it was recognizing that the university has something to offer, recognizing that NGO groups are oftentimes resource strapped. Their mandates are so wide. They're not necessarily in the position to take on a project like this, whereas the university is ideally in a position to take on projects like this, whether it's through our faculties of education or whatnot. But because of the link between the law school and high schools through the Law in Action Within Schools program, it became clear that we could actually design a project on forced marriage that was framed using the language of law. And again, Persia will speak more to that later. But it was that design that allowed us to tap into, at first, small little bits of resources. The Faculty of Law at the University of Toronto initially supported a research assistant to help me manage the research required for addressing the various legal doctrines throughout Canada. The Faculty of Social Work also contributed considerably, both in terms of supporting our principal drafter financially, but also in terms of in-kind support, whether through this room itself or whatnot. The Dean of Social Work, Faye Mission, has been a tremendous supporter of this particular project. We were fortunate, however, to have been able to apply for a special grant from the Department of Justice in Ottawa, Canada, and that particular grant was run out of the Family, Children, and Youth Division in Justice Canada. And I had been in talks with them for many years, particularly my friend and colleague Huri Hamboyan at that division had been a great supporter of this project and wanted to see it come through and felt it was a device that would work hand in hand with what other protective measures that might be implemented. And so thanks to Huri and her encouragement, we were able to secure some funding from Justice Canada that allowed us to bring the project to completion. Laws has been a tremendous asset in terms of helping us design teacher focus groups, helping us take it out into classrooms, do test runs with it, and in a sense create the lab that allows us to test how this curriculum works. So all of these units, institutions, really made it possible for us to do this. Myself as a project director, I have absolutely no experience or expertise in forced marriage, let's be quite frank, but a project like this takes a team, and I was very fortunate and privileged to be able to work with some astounding people. As I've mentioned, Persia, Sarah, and Deepa have all been actively involved in this project. Two other people I want to mention, Alan Hux, who was our curriculum specialist, formerly with the Toronto District School Board. He ensured and helped us identify how and where a curriculum like this might be inserted in the high school curriculum project as the high school curriculum more generally as defined by the Ontario Ministry of Education. And that was a crucial piece for us to figure out what classes, what kinds of teachers, what kinds of issues, what kind of content and language we should be using as we also targeted a specific grade level and specific class content. Andrea Sobko with the Ontario Justice Education Network has also has provided the hub space. So the fact that we are freely downloadable is a large part due to OGEN and its availability and making available its website for uploading all of the documents. And as you'll go through, if you've seen the documents, you'll know that they're quite extensive, both in terms of amount of material, but also in terms of memory space, thanks to the wonderful graphic design initiated by SALCO. And so there is an issue of technology at play here that both can be enhancing of the classroom experience, but nonetheless needs to be negotiated. Can I have the next slide? So just to give a sense of the timeline, this started off as an idea around 2008, but really couldn't take off until 2013. At that time was when I was able to secure some funding for Ms. Jenna Preston, who was a research assistant of mine, to research family law here in Canada, particularly issues of custody, of marriage, marriage age, ages of majority, and guardianship. And why we picked those three legal issues, I'll leave to Persia to explain. But it did take a while, as you see from the timeline. It took well over 2 years to both research, draft the handouts, run teacher focus groups, which are now still ongoing, run a community forum, because we did not want to appear like we were coming into a community-oriented issue without consulting that community. So we wanted to maximize our democratic accountability. In the spring of 2015, we began finalizing the unit and started the translation process. We have translated the final version into Arabic and French and formatted specifically for classroom use. The other versions in Arabic, Urdu, and Punjabi have been translated but not formatted for classroom use. And this raises a larger question for us as a project. In many ways, as much as the university has been a terrific place for thinking about and working through what a curriculum like this might mean, we're also not ideally positioned. We're not ideally positioned to then bring this curriculum into communities. And so that absence of an institutional link into communities is something that has limited, in my view, the effectiveness of our other translation languages in terms of their effectiveness. Just as a side note for those not in Canada, we chose English and French because those are the two official languages of Canada, and so this curriculum has the potential of being used across provinces nationwide, regardless of the language of instruction. And so just after the translations, what did arise in Canada, and again, Persia will speak more to this, is by September 2015, we had to actually take on a number of revisions, because over the summer of 2015, the then Conservative Parliament passed the Zero Tolerance for Barbaric Cultural Practices Act, which was really a piece of legislation designed to target forced marriage. And while that particular name of the bill has left sourness in many people's mouth, it nonetheless is a legislation that affected the way in which we could represent the law to students as we were thinking about what that representation meant for their classroom discussion. And right now we're at a process of promotion and distribution. And so as we come to the end of December of 2015, we're delighted to be sharing this with the Tahiri community. And you'll also hear from Sarah Pohl, who will be speaking more broadly about where this is going, how it's being distributed, and what the reaction will be. And so with that, I'm going to turn it over to, sorry, there's one more slide that I have to tell you about. Casey, yes. So just one of the things that I should reflect on is that this particular project, in a sense, came out of the fact that I was really angry at one point, having witnessed, having been in the classroom and seeing firsthand, learning the story of a young man who had been forcibly married, despite the fact that he had, to all intents and purposes, come out as gay, despite the fact that so that's one. The legislation that we were just talking about in Canada reflects a certain kind of anti-immigrant conservative politics that also is quite exasperating. And also it's my view as a law professor in particular, not just an educator, but a law professor, is that the law has its limits. The law has limits in the scope to which it can really teach people effectively over the long term. And forced marriage, because of where these kinds of impulses are situated, whether it's cultural, social, or whatnot, they can't be legislated in this fashion, or certainly change in these areas are not open or vulnerable to this broad-based kind of legislative enactment. And so it really did raise questions about what would an educational platform look like, how would we target it, and more importantly, how would we get youth, whether of these communities or not, to start thinking proactively about their own agency in a legal environment where, if we see forced marriage as an extreme version of paternalism, we must recognize at the very least that every legal system has a certain degree of paternalism as it looks at youth and the state's responsibility to those youth. And as we characterize that responsibility in different ways, whether paternalism, whether or not, or in terms of the welfare of the people or children's rights. But nonetheless, we are in a position where we are telling students what they can or can't do up until they're some age like 18 or 19, as if magically they become full citizens. And so it's in that context that this particular educational unit is introduced. And now with that, I will turn it over to Persia, who will take us to the next slide.
Thanks, Casey and Anver, for that introduction. So in terms of how we wanted to frame the curriculum, some of the considerations that went into that, we really thought about how to best approach this as a preventative tool and how to appeal to a wide-ranging audience of youth. While the curriculum can be used in sort of pieces and can be really flexible depending on the needs of a teacher, we wanted to frame it a certain way, and that was quite intentional. So we frame it through introducing these 3 topics that Anver mentioned: age of majority, marriage age, and guardianship. Some of the things that we sort of considered with putting the issue of forced marriage just at the forefront was that it sort of leaves the issue more open to be taught in a less informed way or an insensitive way. It might scare off teachers from teaching it. We also really thought about how we wanted to engage students in the issue without sort of having it be like a PSA or overly dramatizing it or having it be too lectury. So this approach really targets the law. It looks at what the law does and doesn't do and what it says about who youth are and what they're capable of. So we thought this would be a good way to engage students because it's all about them. It's all about their rights and how the lawmakers and judges view them. And we have a lot of examples of how cases and judges actually talk about youth in our curriculum. So in a way, it's really about youth empowerment. And then we use these broader themes to get at our 2 sort of special topics, forced marriage and emancipation. So in both these topics, we bring up these issues again, the issues of agency, capacity to make decisions, and in forced marriage in particular, we really bring up the issue of consent. So our goal really is to have youth to think critically about these issues and accordingly the laws around them. Next slide, please. So the actual curriculum is targeted towards older teenagers, so youth between the ages of 15 and 18. So that's typically grade 11 and 12 students. Parts of it might also be able to be used for grade 10 students. It's a curriculum that can be used most obviously in law courses, as it fits in pretty well with the requirements in law. We also have links to international law in the curriculum, and that ties into some of Ontario's requirements for law education in high school. But it can be used either in whole or in piece in other courses as well, including civics, history, social studies. It could be used in gender studies. It has a pretty wide range. As Anver mentioned, it was also intended to be used in the community and with language-specific populations. So we have translations in French, Punjabi, Arabic, and Urdu. And I'll discuss some of the issues around this later. And it's hosted by the Ontario Justice Education Network. So there's a link there in case I think it's also on the Tahiri invite, but in case anyone wants to take a look at it. Thank you. So just to run through sort of the things that we're incorporating in the curriculum, because it is really a substantive legal curriculum, a lot of it is talking about the relevant legal concepts and the laws. We tie this back to rationales, historical rationales in Roman law and in the development of law in Canada for why we have certain age-based laws. We sort of explore why the law has picked specific ages for different things. We also wanted to include real legal cases with very in-depth excerpts from judges' decisions to really show students how judges talk about youth in their decisions. And we have hypothetical case studies as well involving youth. So, for example, we have a case study of a young person who's considering leaving home in the emancipation handout, and we talk a bit about what are the sort of legal rights or limits to that person's rights if they end up leaving home, but also what are some of the considerations or the thought processes that should go into that decision. We also have, we try to make it sort of as engaging as possible, so we have a lot of examples from the media and about things that talk about youth agency and capacity in the media, including links to articles and some opinion pieces. So one example of this is a case in Alberta that got a lot of media attention where 2 high school teenage girls petitioned to lower the voting age from 18 to 16. And I believe there's a similar example of this happening in the US. So we really get students to talk about this critically and whether they think this is a good idea or whether what some of the considerations are that go into picking a certain age to do certain things. We tie in lots of discussion questions to foster critical thinking. Again, like I mentioned, we have links to international law. And we have some additional resources that I'll talk about in the next slide, please. So the actual materials that are in the curriculum, the substantive part is the student handouts. Those are the things that reflect the key themes that we're getting at and contain most of the content of the curriculum. These are oriented towards students, so they're meant to be read directly by students. They also contain discussion questions throughout each handout with lots of room for students to sort of write in their answers if they want to actually just read through the actual copy of it. We also, as I mentioned, we framed emancipation and forced marriage as sort of complementary special topics. We also have two really great resources that I'll talk a bit more about later. One is a graphic novel that the South Asian Legal Clinic of Ontario has given us permission to use. It's called My Choice, Who, If, When to Marry. It sort of brings the curriculum to life in a lot of ways. We also have an article from Maclean's, which is a Canadian nationwide magazine called Against Their Will, which looks at a number of other examples of forced marriage, real-life examples happening to people outside of the South Asian community, so a lot of other smaller religious sects, transgender individuals, etc. We also wanted to make sure to provide students with resources and teachers as well. So this includes, we have a section of the curriculum that includes all the community agencies that work on forced marriage and how to contact them. This includes legal clinics that work with youth in particular. We also have youth health helplines that we provide the information for. We have contact information for people who are traveling abroad. We have contact information for the Canadian government while they're abroad, should they find themselves in some kind of trouble. And we also have information on creating a safety plan, which is something that's discussed actually in the graphic novel as well. That's a helpful resource for students. The teacher's lessons are, oh, sorry, just back, thank you. The teacher's lessons are what our curriculum consultant, Alan Hux, drafted. And these are really just for the teachers. They're based on the material in the handouts, on the graphic novel and on the article. And they really are a guide to teachers and how to plan their exercises around the material provided in the handouts. And they give a lot of suggestions and opportunity for teachers to develop lesson plans around the substantive content of the curriculum. You can go to the next slide. Thanks. So just to go through each of the handouts and sort of what the questions are we're getting at and how this ties into our themes. The concepts, the age of majority, guardianship, and age of marriage concepts are all frequently debated in the law, and as a result, they have a fair bit of case law around them. So we wanted to use this to reveal what the law implies about the capacity of minors to make choices for themselves. So with age of majority, we're looking at what age you have to be to make medical decisions, for example, or to vote. These aren't always the same age. We have, in some cases and in some provinces, you can make medical decisions at 14 or even younger. In other instances, it's 18 or 19. So we look at what the judges really are saying about the rationales behind choosing a particular age. And what does this mean about how a child's maturity is determined? In guardianship, we're looking at what does it mean to be a guardian of a minor and why is this necessary? So we have corollaries between guardianship over young people and their property, so something a parent would do or something a guardian of personal property would do, and also guardianship of incapable adults and how this sort of relates to how this involves the same underlying rationales. In marriage, we're really looking at what are the legal requirements and restrictions for getting married, how is marriage regulated in the law, and what is the law around the age of marriage in Canada. We then use these to get at the issue of forced marriage and conversely emancipation. So with emancipation, we're looking at what are some of the challenges of leaving home, especially when you have limited capacity and rights as a youth. So if you're 16, you can voluntarily leave home, but what are the consequences in doing so? Do you still get financial support from your parents? Can you apply for social welfare, and so on? Forced marriage, that part of the handout, we try to get a bit more personal. So we take the themes from the other handouts and talk about these legal rationales, but we also talk more in depth about how marriage is portrayed, what marriage means, how would you go about making a decision about whether to enter a marriage, what does consent mean. We look at the context of a forced marriage and what sort of the personal, family, community, or legal issues that influence a decision might be. So this handout gets a bit more at the personal issues in a less academic way than some of the other handouts do. A lot of our language, also I should say, in the forced marriage handout is borrowed from SALCO's 2013 report. So we lay out the issue and we sort of explain how it occurs across cultures and genders and age groups and what it looks like. Next slide, please. Thanks. So this is just sort of a taste of some of the cases that we talk about and try to engage students with in the curriculum. We have several more than this, but these are some of sort of the key ones. So in our age of majority handout, we talk about a case called Manitoba versus CA, and this involves a mature 14-year-old Jehovah's Witness. She needed really a life-saving blood transfusion based on an illness she was experiencing. And the issue was whether a court should be able to step in and make a decision that they consider to be in her best interest about receiving treatment, even where that girl herself wanted to refuse to receive medical treatment. So she refused to give consent. Her parents were on board with this. This was based on her religious beliefs. But doctors, regardless, obtained a court order and gave her the transfusion, and she challenged this up to her Supreme Court. So there's a lot of interesting things in there that talk about when a child should be able to make a decision that's really, really critical to their life and whether this is in their best interests. We also talk about Michaela Sue. She was a 10-year-old First Nations girl who chose to stop receiving chemotherapy and instead started using traditional medicine. So again, this was a different province with different legislation, but the issues are the same. They're about whether a young person, especially a young person who comes across as mature, who's evaluated by a psychiatrist, for example, should be able to make a decision for herself to stop receiving something that other people or the state or the court might view as being in her best interests. In Letourneau versus Haskell, this is a case in our emancipation handout, and this one is about a 16-year-old who was unable to live with their mother because of their stepfather's alcoholism and wasn't welcome in his father's home either. So he moved out, but he did not really move out voluntarily. And while the law on child support in Ontario talks about you have an obligation to be supported financially until you're 18, if you leave at 16, that sort of complicates things. So the issue is whether the child's parents were obligated to continue to financially support him, especially because he wasn't really voluntarily leaving. He was essentially forced to leave. The last case is SA versus SA, and this case involved a 16-year-old girl in Ontario. This is one of the few reported court cases on forced marriage in Ontario, and it's a bit old, but it is an interesting example of how the courts dealt with an annulment application for a child that was pressured into marrying by her parents for financial reasons, and whose stepfather, one of the parties pressuring her, had sexually abused her in the past. Next slide. So one of the really key pieces of this curriculum, like I mentioned, is this graphic novel that we got from the South Asian Legal Clinic of Ontario. It's called It's My Choice, Who, If, When to Marry. It was developed in 2012. It's really a visually beautiful graphic novel. It has really lovely illustrations. And it's quite appealing to students because it uses vivid and moving stories of young people who are actually experiencing forced marriage, in this case in a South Asian context, but we have examples of things outside of that context that I'll talk about later. So some of the themes that come up in these stories are around guilt, betrayal, shame, fear, strength, and independence. Some people are able to leave the forced marriages, others are not. The examples involve they're actually all around high school age characters. 2 of them are women and 1 is a gay male who all sort of face the same pressures. So we engage students more emotionally using this novel, but then we also encourage them to apply the legal knowledge that they've gained from the previous handouts and materials to these scenarios. Next slide. So as a corollary to the graphic novel, we wanted to include something that had a lot more diverse examples of forced marriage and the communities in which it occurs or the situations in which it occurs. So we came across this great article by Rachel Brown that was published in Maclean's magazine in January 2015. It's called Against Their Will Inside Canada's Forced Marriages. And it looks at true stories of forced marriage in a number of different settings. And it's sort of our counterpart to the graphic novels focus on the South Asian examples. So we look at scenarios involving people who are in very isolated religious communities. We also have one case involving a trans woman from Mexico who came to Canada after her parents tried to force her to marry in Mexico. Next slide. Thanks. So that's sort of everything I have to say about the content of the curriculum. So once we had gone through our initial drafts, we had a community consultation that the social work faculty hosted, and it included a lot of frontline service providers who were working closely on the issue on the ground. The South Asian Legal Clinic Ontario was a huge help for us in organizing and hosting that forum. So as Anver mentioned, originally we really thought about how we could use this curriculum in the community as well as in the classroom. So the purpose of this forum was to try to explore that more and try to get at how different service providers might try to use this in their own work environment or in their own activism work or client-based work. So some of the themes that came up in this consultation, I think that people really appreciated the orientation and the sort of focus on youth empowerment. There was some talk about just sort of going over the language and making sure that we're keeping an anti-oppressive focus and a framework to the curriculum. A lot of what was interesting to me out of the consultation, I think to Anver as well, was reflecting on how this project might be approached differently in the community versus the classroom. And this sort of ties into the emotional knowledge versus legal knowledge point. So one of the issues, or one of our focuses of this curriculum is on a sort of really law-based academic understanding of the issue. And in a community, this might look different. So a lot of service providers do education that's more popular education focused or focused more on social knowledge or emotional knowledge or is more experiential, for example. In a classroom setting, we're really getting at the substantive law, and this is sort of why it fits in with the goals of a law education in Ontario, for example. We do ask students how they feel about things a lot, and our teachers' lessons get at decision-making processes and the various feelings that youth might have about this, but for the most part, we don't walk students through this. Aside from the forced marriage portion of the curriculum, a lot of the curriculum is about encouraging critical thinking around the law. And that, I think it makes it able to be widely used across the province. But but also means that teachers might want to tailor it differently depending on the context of their particular classroom. And I think it means as well that the community might want to tailor it differently depending on their needs, including who their service users are, whether they're working with youth of a particular ethnic or religious background, whether they're doing work more broadly with women in the community. So I think the curriculum is a really good place to, while it might be focused more on classroom use, it's a really good starting point to additional resources that the community might want to create that's more suited to their own needs. Also, I think one of the limits of the curriculum is that it focuses on really youth agency in the law, and there's a number of other legal issues that come up in community settings around forced marriage. So immigration, sexual assault, for example, those are key themes, and that's not something we focus on largely in part of the scope of our project, our resources and timeline. But those are really interesting things that came up in the consultation about where the curriculum could go and what we could fit into it. And I think that's an interesting place to think about how we could expand the curriculum in the future, or how we could develop sort of side projects that look at these issues more closely. Next slide. Thanks. So partway through finalizing the curriculum, a new bill was passed. The bill is called, it was quite controversial in Canada, and I don't know if that made it to the States at all, but the bill is called Bill S7, the Zero Tolerance for Barbaric Cultural Practices Act. And the name itself hopefully causes you to scratch your head as much as it did for us. It's a bit inflammatory in terms of its wording and the framing of the act as well. So we had sort of a challenge in terms of how we wanted to address this in the curriculum. Just in terms of, just to outline briefly what some of the changes are in the curriculum, the new bill amended the Civil Marriage Act to set out an absolute minimum marriage age of 16 across Canada. So whereas before, the minimum marriage age was typically 16, but there were exceptions to that, and people under 16 could get married in exceptional circumstances. Another, the more controversial change in the bill is that it introduced a new criminal offense under the criminal code. So it's made forced marriage itself a separate offense. It's now illegal to celebrate, which means to officiate with or without legal authority, aid or actively participate in a marriage ceremony, knowing that one of the parties to the marriage is marrying against their will or is younger than 16 years of age. It's also now a criminal offense to remove from Canada a person under 18 for the purposes of forcing that young person to marry in another country. So as Anver mentioned, our curriculum was in part a response to the push for criminalization, and part of what the frontline workers and services that work with forced marriage have been pushing for more of, which is more sort of on-the-ground support, education, prevention, non-legal remedies to addressing forced marriage. Next slide. So the tensions in doing this are that the bill was coming into effect as we were finalizing things. There's also issues. I mean, this isn't just a one-time thing. Presumably, the law will always be changing, and the curriculum is it speaks about the law at a certain point in time. So we thought we would take advantage of this opportunity and sort of involve students in the process of how the bill gets introduced, what some of the reactions to it have been in the community and amongst service providers and amongst activists, and getting their own reactions to the bill and their own thoughts of whether they think the bill will be effective, do they agree with the changes, what do they think about the bill title, do they think this is a good idea at all. To sort of go through our own curriculum and make the proper legal changes to reflect the new laws, we were really lucky to have assistance from the Department of Justice, the Family, Children, Youth section, who took our drafts and just reviewed them and made sure that they conformed to the new changes in the law. But we did want to sort of provoke debate around it and discussion about the changes, the title as well, and of course the problematic implications of the bill. And I think, next slide. I think that's me.
Hi everyone, this is Sarah Pohl. I am the Director of Law and Action Within Schools program. I thought I'd give you a little bit of information about our program so you can see the context that we work in and how we work with Anver and Persia at the law school. So we are a partnership between Toronto's two law schools, the University of Toronto Faculty of Law and Osgoode Hall Law School at York University, and we are essentially the youth outreach program, education engagement program of the two law schools. We've been running for 10 years now, and our goals really are to help youth who would perhaps be the first in their families to graduate from high school or certainly to access post-secondary, engage in their school and think about themselves as positive candidates for post-secondary education. We work with 7 partner high schools in the Toronto District School Board, which it's a huge school board. It's the 4th largest in North America. And we work with partner schools that are spread across the city. This year we're serving more than 1,200 youth, and many of them face really significant personal and or systemic barriers to success in school. They're a really diverse bunch of kids, and for those of you who don't know much about Toronto, Toronto itself is a very diverse city. And that diversity is definitely reflected in our schools. And although all of our schools, it would be fair to say, have populations of kids who face challenges, the schools themselves may have populations that face different challenges or may have bigger populations of students facing particular issues. Many of our students are new Canadians or are first or second generation Canadians. We have 2 main programs. The first is a 3-year cohorted program where students join us for grades 10, 11 and 12, and we work in 2 parts. Firstly, we work with their teachers. The students are cohorted and streamed into Law's versions of regular Ontario curriculum courses. For example, in grade 10 we have a cohort doing Law's English, Law's Science, Law's History, Law's Careers and Civics, and then in grade 11 and 12 we're working with them in their English classes and their law classes. And we're trying to infuse that regular curriculum with law and social justice themes, really to make school more exciting and also to help them develop more skills in terms of advocacy and critical analysis of their society. So the flip side of that is outside their classroom we provide a huge range of extracurricular activities, again designed to let them have positive interactions with members of the justice system, to become really familiar with the post-secondary environment, and again to bring their learning to life. The second program we run is it's for newcomer students working through English as second language classes in our 7 high schools. So these are students who have arrived in Canada and have been assessed by the school board as needing to go into ESL classes. That program is a lot more limited. We run workshops that provide introductory information on fundamental parts of the Canadian justice system. For example, how does the youth criminal justice system look in Canada? Who's involved? What does family law look like in Canada? What does employment law look like in Canada? Etc. Some of the students will float between the 2 programs, but normally they're fairly separate. So that sort of is the context of where we work. In terms of this project, there were 3 main goals for us in being involved. Firstly, the issue of forced marriage was relevant and live for students in our program and also for the larger school populations of each of our our partner schools. Secondly, the topic provided a vehicle for us to help students analyse how or whether the law is effective in protecting and serving Canadians, and as an example for helping them develop their own critical gaze on the law and learning how to advocate for themselves, and also to discuss the issue of personal agency. And third, we were really happy to bring the expertise that we have as a youth serving agency to help Anver create this resource that was going to be used much wider than just the laws program. So we were very happy to partner with him on that basis and to help pilot and sort of test things out in our schools. So, and on that basis, what we have done is we've tested it just recently in a few different contexts. So I thought I would give you some concrete information about what we've done and how that's worked. If I could get you to move, actually, where are we? Yes, okay, well we could talk about the teacher focus groups first. This happened, I think, in the last school year. And it was included as part of a full-day professional development session that we did with laws teachers and our guidance counsellors. And our guidance counsellors, perhaps as many of you have experienced as well, are often the first base for students who are experiencing issues with forced marriage. And often they were the people saying to us, we really don't know what to do or how to help them. So saw this resource as really increasing their capacity. The workshops were also provided at provincial law and social science teachers' conferences, and I'm pleased to say that they were all received positively. Teachers were really pleased that this kind of resource was being created. They saw it as being relevant, and they saw it as relatively easy to incorporate into their classrooms. They're a fairly engaged bunch, the ones who come to our conferences anyway, I think that's fair to say. I think teachers were anxious, as they always are, in my experience, with fitting extras into their curriculum in terms of time out of the classroom or from their regular curriculum. So being able to explain to them how this curriculum piece would actually touch pieces of their curriculum rather than taking up extra time was helpful to them. They did suggest at that stage, and I think that was the stage when we only had the graphic novel, that they really wanted to make sure that the examples that we were using were showing a wide diversity of religious backgrounds or ethnic backgrounds to make sure it spoke to all students, and also wanted to make sure that we were able to speak using the resources to the positive aspects of all these different cultures, so making sure that students were able to feel pride in their own culture as well. So next slide, please. So in terms of what we piloted at, firstly at a multi-school conference held at the University of Toronto, which was interesting because it was actually students from across the whole school board, so not students that I'm familiar with, so it was, and not students who knew each other, so it was an interesting mix. And then secondly and thirdly, I've been piloting the resource at two of our partner schools, Westview Secondary School and Central Technical School, which are both really large, diverse, I guess kind of thumping high schools, one downtown in Toronto and one up in the northwest of the city. And they were in grade 11 law classes, which is an open course in our curriculum. And really what, if we could skip on to the next slide, please. And I have an outline of really what I did. We generally get 60 minutes in a classroom, and that's 60 minutes beset by lots of interruptions. Our classrooms are fairly dynamic places. I think it's fair to say in the laws program. And I really realised that what we were doing is taking a lot of pieces of the different aspects of the different sections of the curriculum that Persia had developed and having to condense them into the 60 minutes. For example, really trying to give our students an overview of agency and what rights and decisions they had the control over at different ages, and then rolling into a definition of marriage and what you needed to be able to get married in Ontario and who had the say, and then actually moving into forced marriage itself. And I think it's fair to say that in the classrooms that we were working with here, while we were obviously talking about the law, a lot of it that we were dealing with our kids, our students, was really on this emotional knowledge and more of a conversation about agency of decision making in general. So you can see my outline there. What decisions do you make for yourself? Who influences decisions that you make? What decisions do you seek guidance on from other people? And if so, who do you seek guidance from? What is marriage? What do you need to do to get married in Ontario? What age do you have to be? What consent do you have to have? Who can you marry? You have to already not be married. And then why do people get married? So we're sort of branching into more of a conversation about social norms or expectations of yourself or your family or your community. And definitions of which Persia had provided. So what is forced marriage? What is arranged marriage? What does duress mean? What does consent mean? And then a conversation really about asking them to brainstorm on what would influence their personal decision to get married or not, and what expectations or other people's influences would they be facing in that decision. And then we went straight into the case studies. So we were using some of the examples from the graphic novel and also the examples from the Maclean's magazine. So students would read them individually. They would then do a think, pair, share exercise where they would buddy up and answer some questions about that we'd prepared through a worksheet. So what were the positions of the youth involved in terms of how do they feel about marriage, how do they feel about this marriage, what were the parents' perspectives or guardians' perspectives, what was the community's perspective, what options did the youth have, and what were the legal issues, so at that stage applying the law. And then each group presented to the class, so the class was able to hear all these different case studies and hear about how the similar issues of duress or shame or betrayal were playing out across all these different cultures, which was interesting. And then the wrap up for us, we really touched on the law and what the law says now, and getting students to think about if the law was helping, and what other aspects of support students or youth would need to be able to face these issues themselves. We talked a lot about helpful agencies, we talked a little bit about the escape plans, etc. So really trying to let them leave having sort of sparked this conversation in their mind about this issue, and also thinking about if this is coming up for me or a friend or a community member, how can I actually help them, let them access help. I also asked them for some feedback. On the next slide, you'll see some feedback from one of the examples we did, one of the pilots we did downtown actually last week at Central Technical School. So the main feedback I was getting from students was that they really appreciated the fact that they were getting to examine real cases and really see how these different situations were playing out in their actual community. They liked the fact that the people in the religions were all different who were represented. They liked discussing why people get married and what pressures people faced, and you can see there students saying, I like the brainstorming. And then it's interesting, even in this one class, we had one student saying, I didn't know this stuff was happening in my community, and another student saying, this story completely described my dad exactly. So even within a really diverse class of law students, very different understandings of this issue. They liked that it was interactive, being able to share their thoughts, etc., etc. They really liked the comic. The graphic novel is fairly amazing. And if you skip over, because it's youth, of course, they tell me how it is. So I think the funniest one I got was it needs games. I'm still questioning what kind of games they wanted in a forced marriage workshop. They did feel that, I think a lot of them were stopped in their tracks a little bit about the reality of the situation that people, their peers, were experiencing. So they found the stories real and brutal but sad. One student found it a little too deep. But actually that student was really interesting because he stayed afterwards to speak about it. So although he thought it was deep, I think it really did trigger in him a desire to have further conversation. And one student just wanted to sit there afterwards and read all the stories himself, which was wonderful. And of course we got the you made me write too much, which I'm used to. So then on the other page, just in terms of some other feedback, we've struck a bit of a teacher work action here in Ontario, in Toronto, so we weren't able to pilot as many as we could in schools, but we have had 2 more of our partner schools requesting the workshop. I'll be doing some on Thursday and then some in January. I think the biggest, one of the biggest things for me with this has been we did receive a no from one of our partner schools when we had proposed doing the workshop with one of their newcomer classes. And the principals, and this was being relayed through me to a teacher to the principal, so perhaps I didn't get the chance to explain the resource as best I could have, but she felt that the resource, doing a workshop on forced marriage would paint the whole community with the same brush, and it's not a message that she would like her school to send to the community. Which is interesting. I think that school in particular has a very interesting mix of populations, and many of whom are newcomers to Canada. So I was actually really keen on that school in particular. I thought that this might be helpful information in terms of agency in general. And to give her credit, the school, we've also just recently been dealing with a new sex ed curriculum in Ontario that has been met with different reactions by different groups, and that school lives in a community in Toronto that I think has had quite a strongly negative reaction to some aspects of that curriculum. So she's trying to hold all this together. There's also been at the school a physical attack on one of the parents recently. So I'm hoping to go back to her and we'll have a chat about how we could maybe introduce the topic perhaps by really focusing on the youth agency or age as a majority workshop first and then lead into forced marriage. But anyway, thank you.
Hi, so this is Deepa. I'm from South Asian Legal Clinic. So I'm going to very quickly, in our next 10 minutes, talk about institution, communities, and services, and the role of institutions and communities related to a project like this, and the experiences we have shared. So in terms of the work forced marriage activists have been doing here in Canada, I think we all have been grappling with increasingly complex and sometimes controversial issues which are kind of brought in front of us. Sarah kind of alluded to some of that stuff in her presentation, and so did Persia. The problem is that since this work involves creating accountability, it doesn't make it easy at all. And any kind of multi-sector partnership like this project also makes it really, it creates a challenge for us to make sure that the partnership is well-informed, effective, and meaningful for all the contributors at every time. So very briefly, telling you about the Forced Marriage Project at SALCO, the mission of the project has been for a while to create a dialogue on the issue of the forced marriage, and this project definitely fits very well with the few things which we want to achieve with that, which is prevent coercion, promote safety, and build community accountability. We have a project advisory committee, and we have a network of agencies against forced marriages, which Professor Anver has been part of, I think, ever since it was started in 2005, 2006, and therefore for us, the partnership on this project was a natural fit. Moving along, we at SALCO have always made into our prime important, like we have always made it into our prime important issue that every time we talk about forced marriages, we do not forget the fact that these practices happen in the context of certain issues. They don't happen in silos. They happen in the context of where our communities are. And we also very strongly believe that although there are no excuses or valid justification for the practice of forced marriages, but we have to note every time that when we are talking about it, that the individuals who are being forced into these marriages are often themselves victimized by the complex interacting factors. And what is good about taking an issue of forced marriages in a form of a curriculum to the high schools is that if they have the whole package the way they have, and they have the reading materials from the NGO communities, they have critical analysis and the context as laid out, they would be able to analyze the issue in the fact that the communities which practice it or face it also face immigration control. They also face hard economic conditions and poverty. The school Sarah just gave us an example of is, and where the principal is really grappling with the same complex issues, whether I should bring this to my students or not, is a prime example of that. When communities live in certain conditions, which is economic, where there is racism or where there is xenophobia, the chance have some unique challenges in addressing these issues, such as so-called honor-based violence or forced marriages. SALCO has therefore in its work, and so our work, which is part of the curriculum, which is our comic book or our report, kind of stands by the fact that anytime you're creating any curriculum, you're creating any work, you have to make sure that the materials have an anti-racist and anti-oppressive approach. And hence, when Persia was discussing the process of community consultation, that's why it was kind of highlighted that was the main theme which emerged from those consultations. We also believe that institutions need to make commitment in fighting this form of violence and abuse of human rights. So from the school system, making a commitment of bringing this curriculum to the schools is definitely a one step towards it. Similar to the building up public and community accountability and creating safe spaces that encourage open and inclusive dialogue. It's really good that students in a classroom setting are able to analyze what's going on, and they are able to engage with the topic in a more safe and inclusive manner. We also strongly believe that services which are created out of any of the projects include both men and women and people of all sexual orientation, which definitely is a good fit with the project we are talking about today. One of the main things which kind of is something which jumped at me from the fact that since now we are taking it out to a community which probably has not interacted with the topic as much, there is many times a reaction which comes from the community saying, we don't know much about it and you're bringing this topic to us and how will we deal with it? So what we have been saying is for a long time that any education approach which emphasizes an informed dialogue definitely can get assistance from the established domestic violence resources or established violence against women resources, because in terms of addressing the issues which come up out of any education like this and awareness building, there is a responsibility which comes with creating a framework for social services which goes with it closely, because with increased awareness and with increased education out there, the NGO community definitely on its own in the way it is framed right now would not be enough to serve. So the school systems and their own social change within the framework, how they operate, also need to be addressed, and maybe at this point we need to maybe make sure that they're involved with the project a little bit more, so that the people getting this knowledge also can get appropriate services. In terms of the consultation and community accountability and the complexity for the victim and for community, because I thought we should talk about both, because a lot of people we are talking to through the curriculum might be victims themselves. They might be witnesses who have seen this kind of violence, or they might be people who have known someone. So the consultation piece in terms of creating a dialogue space, in terms of creating a context in which this is happening for them. I know that there was a discussion about the context of the classroom and how the materials are meant for them, but that's one of the things which I think we have kind of looked at and talked about in past, is that that the victims can have various consequences. They can vary from something like there's a coercion happening right now. It might be something related to their immigration status, or any other, or estrangement from the family. Whereas for the community, we feel that there could be a fear of further stigmatization and stereotyping, which we have seen from Sarah's example. It's actually interesting that how Sarah and I never talked about it before the presentation, but it fits in right well there, because there's also a heightened racism and xenophobia which can be created by this kind of dialogue. There could also be increased incidents of violence in the community. So those are some of the control mechanisms which we believe need to be created in terms of any of these partnerships. The NGO communities are pretty diverse in their nature, and sometimes when we are trying to create or looking a community consultation or community framework, it is important to kind of learn from the experiential knowledge of the communities or the NGO community in general, because it's interesting that materials which, as Anver mentioned, materials which are very good fit for the classrooms might not be a great fit for the communities because of the language and the framework which is being used. So the question then becomes is, how do we make sure that it has that a nuance of adaptability for the communities, to make sure that the accountability which we want to create at every level is achieved. With that, I think I would finish. I just want to thank everyone who has been involved in the project and also thankful for using SALCO's resources.
Great, and I just wanted to say thank you to all our presenters, but also to really encourage, we still have a very high number of people still with us on the webinar, which is great, and so if anyone has been holding questions or has a burning question to ask, please take a moment now to type it into that question box and to share it with us, because we still have about 20 minutes left for question and answer. So I'm going to give people a few minutes just to put some questions out there for all of you wonderful presenters. So we have a question. Oh, sorry, we have a question from a participant really quickly.
Sure, go ahead.
Wondering how exactly forced marriage is defined in Canada in the law.
Hi, this is Persia. I don't know if I don't know the legislation too closely, so I'm not sure if the definition is actually provided. I might throw this to Deepa if she has an idea.
So yeah, I mean, there are two different definitions which are kind of floating around, and they basically are very, they kind of mirror each other, but not so much. In law, with the bill S7, there has been usage of a language around saying a marriage, so it's a reverse definition if you look at it, because they define what should not be in a marriage, which can make it into a forced marriage. So I'm looking at it right now to read it exactly to you. So it says it's an offense to celebrate, aid, or participate in a marriage rite or ceremony, knowing that the persons being married doing so against their will or under age of 16 years. And then there is another one which says something about the enthusiastic involvement in the marriage, so which was pretty interesting for us, all of us, and we all were like, what does that mean? Because it talks about that you have enlightened, sorry, it's not enthusiastic, it's enlightened consent into a marriage. The other one, which mostly NGO community uses, talks about forced marriages as a form of marriage where one or both the parties do not consent, and it can happen to anyone of any age, any gender. It's pretty much from how UN defines it, basically.
If I could just add a couple points to that question, I do think that it's fair to say that at least the Bill S7 that became law in summer 2015, on the one hand, it was targeting forced marriage in part because the Foreign Affairs Department of Canada has carriage of the issue in consular affairs internationally. So the funding that we got from Justice Canada was actually coming from Foreign Affairs to Justice, and Justice Department managed the funding. So there is a connection between Canadian foreign leadership at that time under the Conservative Party and the specific grant that we applied for. Second, though, the fact that it's defined negatively is also a vehicle by which to not define forced marriage. It plays into ongoing contestations between how do you distinguish between forced and arranged marriage, which no one seems really quite capable of addressing, and which has come up in some of the focus groups as well in terms of a point of ongoing contestation. But the last point I want to address is that how this curriculum actually doesn't rely on the law. I mean, it should be emphasized that we're not, though we are, I'm a law professor, this was organized out of the law faculty, we're not using the curriculum as a vehicle of legal advice. We're not trying to advise students as to their rights under the law. Rather, what we're doing is we're using law as a cultural artifact to try to address what it is what it means for students in this 15 to 17 age range, for instance, to talk about themselves as both citizens but also as wards of the state, as minors. They do not enjoy the same sorts of legal privileges that others who are older than them do. And so what does that mean about them? How does the law look at them? As a law professor, where I'm often teaching my students that you must adjust the legal application to younger members of society who nonetheless might break the law, might injure someone, might run into issues of liability. But part of what we're doing is we're also revealing to the students what we call the culture of law. And so I also want to make it clear that that's also a key feature of what this curriculum is doing. It situates itself within law and cultural analysis.
Great. Thank you so much for that. And I think there's actually been a question that's come in that sort of is a good follow-on to that. And the question is, what is the team's understanding about the new government's intentions with the Barbaric Cultural Practices Act? And do you anticipate another need for changes to the curriculum based on what the new government might be doing in response to that act or not doing?
It's hard to answer that question. The new government has only been in office quite recently, and frankly, the attacks in Paris have caused some problems even in their campaign promises. We do know that the Conservative Party, when they campaigned for the federal election and lost, used the language of Bill S7 to posit the idea of a barbaric practices hotline or toll-free line. They were deeply criticized by some as for doing so, but others were quite open to that idea that they were playing to a certain kind of voter, and we can discuss, that's not really for now to discuss who they were playing to. So one hopes that that kind of institutional expansion of this bill will not occur under the Trudeau government. But I do think it's still too early to figure out what it is they intend to do with this legislation, though I can't imagine them voting against it. My understanding is that their own dislike of the title, nonetheless, it did not preclude them from voting for the bill, even when they were a smaller portion of Parliament. So they still did vote for the bill, the Liberal Party, when they were in the previous Parliament. And so I don't anticipate major changes.
The other thing is that there has been a lot of changes which were made. So as far as the activist communities are concerned, within the immigration context, there will be a lot of changes which are being requested to be taken back or revisited, and including some of the changes which affect forced marriage victims through conditional permanent residency within the sponsorship scheme of spouses. I think there will be a long list of asks, and it's hard, as Anver said, it's hard to say what will be taken back and what will not be, what will be the priority to be not be included. But from the opposition point of view, I think our majority opposition party, I think, did not vote for it, the NDP, and I think they will probably still voice against it. Just very quickly, for people who are interested in the definition, there is another definition which under the immigration policy bulletin on conditional permanent residency is given. It's a very lengthy definition, but it's definitely kind of reflects as I said about the NGO definition, it reflects that. But anyone who's interested, it's part of the Operation Bulletin 480 of Citizenship and Immigration Canada, now called Refugee and Immigration and Citizenship Canada, and you can see it there.
Great. Thank you so much to you both for answering that. We actually got a response that said it was really helpful answer to their questions. So that's always a good thing to hear. There are a couple more questions. One that has come up, which is on the topic of criminalization of forced marriage in the UK, and a participant wanting to know what the experience has been with criminalization in the UK. And I think, you know, in terms of today's presentation, there probably isn't too much that we can say on that, but I think Tahereh has actually undertaken a pretty extensive consultation process with advocates in different countries where forced marriage has been criminalized, and in particular in the UK, I think as we are seeing in many places, there is a division among advocates and service providers about whether or not criminalization has had more of a chilling effect, so driving the practice underground, or more of a deterrent effect, so preventing it by putting legal consequences in place. And in particular, what we did learn is that there had been a decrease in the numbers of calls to the hotline around forced marriage after criminalization as compared to prior to criminalization. And the interesting thing about that is that it's impossible to say why that decrease occurred. And so there are a couple of things that people are discussing right now, and it's, first of all, the data, the way in which it was collected, was altered around the same time. And so whereas the FMU used to simply aggregate all data that came to the forced marriage unit hotline, whether or not it had to do specifically with a forced marriage case or whether someone was calling the forced marriage unit hotline, but to discuss something more related to female genital mutilation or cutting or some other form of, what they would term honor violence. All of those calls were being reported out as having come to the forced marriage unit in years prior. And so the year after criminalization, what they did was actually disaggregate the data to say these were the number of calls that specifically came in around a forced marriage case, taking out the chunk of calls that didn't have a forced marriage element to them. And so I think there we're obviously going to see a decrease, but even if that, if you look at the data and we find that that's not the case, it is really hard to tell what we've heard from advocates and the government whether or not this decrease reflects a deterrent, less people trying to force their family members into marriage, and that's why we saw less calls, or whether or not this decrease reflects a chilling effect where people were just now far too scared to come forward to even ask for help for fear of the potential criminal consequences for their family members. And so it really is very difficult to say right now what the fallout of the criminalization has been, but we do know that advocates and service providers and survivors themselves are still divided about whether or not it was a positive or a negative stance to take, and whether or not the result has been positive or negative.
Cassie, can I quickly add one thing? Yeah, so the only case which has been reported to be, which was reported as the first ever forced marriage conviction in UK, if anyone who's interested in UK and the criminalization model there, I would encourage you to look at that case very closely. It's a case of, as it was described, of someone who was trying to force someone to marry him as his second wife, which in itself would have been a crime here in Canada, and as bigamy. And the person was also charged for rape, bigamy, voyeurism, stalking. There was a whole list of other criminal charges against him, and forced marriages was one of the things thrown in there, kind of a thing. So I would really encourage people to read upon that case to kind of get a sense of where are convictions going, for sure, as part of the analysis around, does it really help it to have in criminal code?
Great, thank you, Deepa. There is one last question which I would welcome anyone on the team to answer, and it's coming from someone who is wondering if there's an opportunity to adapt the curriculum for those perhaps looking to do work overseas or already working in vulnerable communities overseas, if there's an opportunity to adapt and build capacity for the use of that curriculum in that way.
I can perhaps speak to that. I mean, in terms of the project here, we've concluded and wrapped up our funding for it. So just to give you your audience a sense of just the numbers associated with a project like this, between the different units that provided financial support, this project took about $50,000 to put together. I'm estimating the cost. And so we've run through our funding cycle. So if the question is whether we're able to take on someone to adapt it, we're not able to do so. However, The unit itself is designed around these three main tropes: minimum marriage age, age of majority, and guardianship, with forced marriage and emancipation as our I guess you could say our hot topic buttons. And it would seem to me that any jurisdiction, any legal jurisdiction, will have those kinds of concepts. Certainly any modern state will have those concepts. So from the perspective of adaptation to another context, whether the U.S. in the various states or in other countries that are less developed, it's simply a matter of doing the research. That was the initial hurdle that we had to pass, was what exactly is the state of the law, and also not wanting to be caught in the position of giving legal advice. How do you frame this so that rather than giving legal advice, you're using the law as evidence of something else, i.e. the law's culture on youth agency. So in many ways, the virtue we feel of a project like this is that it is highly replicable across different jurisdictions, as long as you have the necessary expertise to figure out what the legal analysis is. And so I'm not saying you can just simply cut and paste from one jurisdiction into our handouts, but it doesn't require a whole lot more. In the sense the template is there, and we would welcome news of anyone who is actually expanding this for application in other contexts.
Well, that's great. And I think, everyone will have your contact information at the end of this webinar. And so if people are interested in getting in touch with any of the presenters, they're more than welcome to do so. The slides and the webinar, again, are going to be available online. You can also view the full curriculum online at the link that we've provided, which we'll also share in our follow-up email with a evaluation link. So we hope that you will take the time to give us feedback about this webinar, and that will be sent out later today. So feel free to utilize all of those resources, and again, the webinar and all the materials will be available on preventforcedmarriage.org. And just want to say a big thank you to everyone, all of our presenters. I know a lot of work went into getting this presentation together. It's a big team, and we really appreciate it. So thank you all so much.
Well, thank you for the invitation.
Absolutely. And have a great day, everybody.
Thank you.